May I reserve 4 minutes for rebuttal?
Certainly. 4 minutes.
The evidence presented at trial is insufficient to establish that Mr. Hoyle possessed a firearm. The trial court's imposition of the maximum 20-year sentence for a single firearm conviction was an abuse of the trial court's discretion. For sake of argument today, though, I'm going to focus on the possession issue and rely on the arguments made in Mr. Hoyle's principal brief regarding the sentencing issue. This case presents a very straightforward sufficiency issue because the state's proof at trial amounts to nothing more than Mr. Hoyle's brief presence in an area where a firearm was located. The state argued to the jury that Mr. Hoyle actually possessed a firearm, even though not one state witness could testify that they saw Mr. Hoyle with the firearm on the night in question. Mr. Hoyle briefly passed through an alleyway where a firearm was located. When he was met with Jackson police officers, he admitted to them that he had discarded a small amount of marijuana, and for that, he was taken into custody. After Mr. Hoyle was taken into custody, Jackson police officers continued to search the area for a firearm. But I would like to remind this court that not one officer saw Mr. Hoyle with a firearm that night. The domestic disturbance call that brought officers to the scene in question to begin with did not mention a firearm either. The state's proof did not establish that Mr. Hoyle possessed a firearm. Under the state's theory, if contraband were to be found underneath the bushes next to the steps leading up to this courthouse, each and every one of us who simply used that pathway to enter this courtroom would be in possession of that contraband and subject to criminal liability simply because we passed by it.
Well, it was a little more than that, wasn't it? I mean, so the way I understand it is he was seen on video or maybe even in person after the domestic disturbance call with a jacket over his arm, and one of the officers testified about how that looked and what that looked like. I mean, it sounds like for sure nobody said they actually saw him with a gun.
Correct.
But it's not like he just was out with both hands wide open and could not have had a gun.
Well, I guess to clarify, Your Honor, the fact that Mr. Hoyle was simply carrying his jacket in his arm instead of wearing it is all that the officer testified to. The officer could not testify that they saw anything that even resembled a firearm in Mr. Hoyle's possession, and this was just merely speculation, a gut reaction, I would suppose.
I think he said he thought it looked like he was concealing something. I agree with you, he didn't know, but he did say it looked like he was concealing something under the jacket the way he was holding it.
I think I would disagree with that, to that, I guess, position. I think the record says that it just simply looked like he may have been concealing something, but definitely not a firearm. And he completely said that it was reasonable to believe that there was nothing under his jacket except for a firearm. I also want to highlight the fact that when Officer Caldron approached the hotel, he was presented with the front desk clerk, and he pointed out Mr. Hoyle on video and that he would be exiting the hotel room. Even then, the officer could not say that, Mr. Hoyle had anything that looked like a firearm at that time. I think the body camera footage in this case would also be telling of that.
And we have that in the records, correct?
Yes, you do. Where Officer Caldron admits that he didn't see anything. His testimony at trial was a little bit different than that, to where he explained that he could have been concealing something. But his immediate reaction was that he didn't have anything.
But I think, from what I've read, is that he sees the defendant has a coat over his arm, looks like he's hiding something, doesn't know what it is. The defendant then takes off running, and they chase him down this alley. The other officer winds up catching him. I think one officer fell down, and one officer winds up stopping him. And they find on this route that he was running, up on top of some rocks or over some rocks, they found the pistol. And so there were a lot of moving parts here. And again, it was circumstantial evidence, but you would agree that a jury could convict on circumstantial evidence if they accept it.
Sure, I would agree with that circumstantial evidence is enough to convict someone of possession possessing a firearm. But I think there's a little bit of tension in the case law on this point because proof of one's mere presence and proximity to an area where a firearm is located is not enough, albeit if that evidence is direct or circumstantial. And in this case, that is the most evidence that we have from the state on this point.
Other than I think, one thing, if he was just standing on a street corner and they find a gun in the grass behind him, that would be much more illustrative of what you're saying, as opposed to someone who appears to be holding something, goes running through an alley after he sees the police, and then they find a gun that's on the path of running, and then when the defendant is stopped, he says, yeah, I've got contraband on me. I mean, I think that there's more to it than just mere presence at a particular location, and they just happen to find a weapon there. There's a lot more moving parts than that, isn't there?
Okay, so I would acknowledge that the proof did show that Mr. Hoyle was carrying his jacket. That's what we do know, and that he passed through an area where a firearm was located. Just to give the court a little bit more context for this area was on one side, a strip mall was located, and on top of a 9-foot wall is where the firearm was located. And on the other side of that wall was a residential neighborhood, which is in fact a public place. Mr. Hoyle, nor any of the officers, or anyone in here for that matter, was in exclusive possession of the place where that firearm was located. It was not visible from the path that Mr. Hoyle and the officers proceeded through. It was also not accessible from that pathway either. An officer had to climb up an embankment just to view the area where the firearm was located. And because of that, I believe that the state was required to present additional incriminating facts to link him to the firearm, because he was not in exclusive possession of the place where it was found, and the fact that the evidence really does show that he simply passed by the area where it was found.
You're basically asking us to say this was a jury trial, I take it,
Yes, Your Honor.
that this jury would not be rational to say beyond a reasonable doubt there was possession of a gun.
Correct.
Yeah, okay.
Yes.
Okay.
And I think the case law supports that. I cited a case, State v. Steiner, where this court kind of illustrates upholding the principle that mere presence and proximity is not enough to establish constructive possession of a firearm. In Steiner, Mr. Steiner was the front seat passenger of a vehicle that was pulled over. A loaded firearm was found underneath his seat. And declining to find that Mr. Steiner was in constructive possession of that firearm, this court noted that when the officers approached the car, they did not see Mr. Steiner make any movement suggesting that he had reached under his seat beforehand, or the fact that a fingerprint analysis was not conducted on the weapon. So here you have a firearm that's located 100 feet away from where Mr. Hoyle was arrested, and no fingerprint analysis was conducted on the firearm to connect Mr. Hoyle to that firearm. Additionally, an officer testified that the gun had rust on it. And based on the officer's testimony, rust is consistent with a firearm being outside for an extended period of time, which goes against the state's theory that it had just been thrown up there, I guess, moments prior.
Was there something about it having dirt in the barrel or something also?
Yeah, there was testimony to that as well. I think it was a winter at the time, so it was humidity in the air, possibly dew on the ground, and the officer noticed that the dirt in the barrel was dry and not wet. So that also, I guess, points further to disconnecting Mr. Hoyle from the firearm. So I think that this case does boil down to Mr. Hoyle simply being in an area where a firearm was located, because the domestic disturbance call didn't mention a firearm. The video or the front desk clerk didn't mention a firearm. No officer saw Mr. Hoyle with a firearm. And for that, we ask that this court reverse the judgments and vacate the convictions. Reserve time for rebuttal.
All right, thank you. General Coleman, good afternoon.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments in this case because the evidence overwhelmingly establishes the defendant's possession of a firearm and because the trial court properly exercised its discretion in imposing the maximum within range sentence.
All right,
for
you
that.
really think it overwhelmingly establishes that?
I do think so. I
I've
will.
got to say, that sounds like a stretch based on this evidence.
I would say this is about as solid of a case that you can get when it comes to circumstantial evidence. Admittedly, there is no direct evidence. The defendant is correct with that. No one saw the defendant with a gun in his hands. But the amount of evidence that circumstantially establishes that he was the one who possessed this weapon is quite significant. And the defendant, I heard repeatedly say his brief presence in the area, his mere presence in proximity, he was simply in the area. And so I'd like to take a second to sort of clarify the facts. I think, Judge Campbell, you did a good rendition. I don't want to repeat what you said, but the facts in this case are pretty damning. So 2 police officers are called to a disturbance to a hotel in the early hours of a morning, early morning hours. And when they get there, Officer Calderon has a partner. His partner starts speaking to a woman who is clearly in distress. He goes and starts talking to a clerk. And the clerk, they're talking and they're looking at the live feeds of the cameras around the hotel. And this is all on body cam, so this court can see what happens. And the clerk points out and says, that person right there was involved in whatever this was. And there's no indication at that time that there was a gun or anything, but that's a person of interest that you want to go talk to. And so this is where we start to see the indications that all, when built up, establish circumstantial evidence to establish the defendant's possession. So the clerk points out and says, that person is involved in this, you'll want to go talk to him. And Officer Calderon goes and starts to talk to him, or starts to approach him. And immediately right off the bat, he noticed, and this is page 42 of the transcript, he was concealing something. I think the defendant indicated that he was just holding his jacket. Testimony was he still kept his right arm close to his body, still concealing something underneath his jacket. We don't know for sure that it's a gun at that time, but he's concealing something, he's acting strange. The officer approaches him and says, hey, can I talk to you for a second? And the defendant, instead of responding, says, no, he went that way. He went that way. Look away. Go away that way. And then immediately the officer isn't distracted, continues to approach him, and the defendant immediately flees. Takes off, starts running. Officer Calderon continues a foot pursuit and starts chasing the defendant. The defendant turns into this back alleyway where there's a strip mall and a wall, and Officer Calderon at that point falls down. Right about where the defendant is in the back alleyway somewhere. While this foot chase has been going on, a different officer has pulled around to the back side of the alley. And that's where the defendant's running through the alley. He goes and he hides behind a dumpster, and that officer is the one who finds him. And when they apprehend the defendant, another telling factor is the defendant repeatedly, to a suspicious point, emphasizes the fact that he had marijuana on him. This court can review the body cam footage. It's somewhere around 20 times. I had marijuana, that's why I ran. Marijuana, 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 marijuana. And officers do find marijuana by the dumpster, but they also find the jacket further away from the dumpster, indicating that he tossed something, and they decide to backtrack. Where's this alleyway that he fled down? Let's go and look. And upon looking, that's where they find a weapon.
How close was the weapon found? I know it was up on the ledge, but in proximity to where the jacket was below.
I don't think there's exact testimony. I think the jacket was between 50 and 100 feet from the dumpster where the marijuana was found, and there's a map that this court can kind of see, but there's no direct testimony how far the jacket is from the firearm.
There's a map showing where the evidence was located.
Yes, there's sort of an overhead satellite view of the back alleyway and where the berm is and where things were, and then there's a more close-up picture of where the firearm was found. The firearm itself was only 2 to 3 feet past the top of the berm, and the defendant attempted to point out that on the other side, if you keep going that way, that there's another public place there. But there was direct testimony that there was a tree line there, and that those trees were 6 to 8 trees deep, that they were thick. So that's not an area of normal ingress and egress to that area. So that's minimal access to the public on the other side of the berm. And here, when we are viewing the evidence under a sufficiency analysis in the light most favorable to the state, and to your point, Judge Wiedemeyer, asking, could a rational trier of fact reasonably conclude that all of this circumstantial evidence puts the gun in the defendant's hand until he throws it away when Officer Calderon falls down. The evidence, I would submit, is overwhelmingly yes. Even if it's not overwhelmingly yes, the evidence is certainly sufficient.
It's whelmingly.
It's whelmingly.
Yeah, not quite overwhelming.
Yes, Your Honor.
All right.
It is at least whelmingly sufficient.
I'm not even sure if that's a word, but it seems appropriate.
But
So how do you distinguish the Signer case?
so I think
Talk to
that's
us about
interesting, and Signer, there aren't all these other telltale factors. There's simply they pull him over, and there's a gun where he happens to be sitting on the on top of it, or it's underneath his seat. But here you have all of these other factors that go towards the defendant's guilty state of mind and the likelihood that he knew where the gun was, that he in fact threw it onto the berm. So instead of having that, again, to use the defendant's language, his brief presence or his mere presence and proximity to the weapon, you have all of these other factors where he's hiding he's hiding something, and then he takes off as soon as officers want to approach him. As soon as an officer falls down, while he's near the berm, they find a gun in that general area, and then he attempts to throw the police off of that trail by heavily emphasizing the fact that he had marijuana on him. And so the defendant's final points about sufficiency are that there wasn't a fingerprint analysis done, that there might have been some rust on the weapon, that I believe Judge Woodmeyer, you pointed out there might have been some dirt in the barrel. All of that goes to weight. Those were all presented to the jury. The jury considered that, along with all of the other proof, and determined, reasonably so, that that didn't outweigh the likelihood that the defendant possessed the weapon in this case. If there are any questions about that, I'll briefly say that for the within-range sentence, the trial court found the presence of multiple enhancement factors, several of which it gave great weight to. It declined to find the fact that the defendant had 9 children, 5 of whom were born in the year before the sentencing hearing. As mitigation, it properly exercised its discretion. If there aren't any further questions, we ask that this court affirm the judgments and the sentence. Thank you.
All right, thank you, General Coleman.
The evidence does not overwhelmingly establish that Mr. Hoyle possessed the firearm in this case. Because again, no officer saw Mr. Hoyle with a firearm, and nothing that drew the officers to Mr. Hoyle in the first place indicated anything about a firearm. The jacket in this case, just to clarify, you'll be able to see that in the body camera footage of Officer Calderon, was located near where the marijuana was discarded. So again, the jacket was a ways away from where the firearm was located. I also want to highlight, again, that this firearm was found in a public place that was not in the
What about the tree line? I mean, talk to us about that.
So either way, Mr. Hoyle was not in exclusive possession of the place where it was found. Clearly, it was still accessible to people, even if not easily accessible. It was still accessible to the public. And it doesn't diminish the fact that a strip mall was located on the other side of it, which is a heavily trafficked place, which was testified to.
Is the strip mall's on the lower side, like close to where he was running, and then up the berm were the trees, and then beyond the trees, a residential area.
Right.
Am I getting that right?
Correct. That's correct. So because this place was not in exclusive possession of Mr. Hoyle, the state was required to submit additional evidence to link him to the firearm. In attempting to distinguish the Signer case, the state mentioned that the gun happened to be underneath Mr. Signer's seat. I would submit to you that that is exactly what it looks like in this case, that the gun happened to be in an area where Mr. Hoyle happened to pass by. And flight alone, speaking to the totality of the circumstances and the other things that the state mentioned regarding the guilty mind maybe associated with Mr. Hoyle possessing a firearm, is that there are multiple facts in the record from which the jury could have inferred a guilty conscience associated with Mr. Hoyle's flight. And flight alone is not sufficient to uphold a conviction for a specific criminal offense.
But it is something they can consider with all of these other again, all circumstantial. I don't disagree with you on that. It's certainly all circumstantial. But they can consider the flight.
Yes, they can consider the flight, surely, but I guess on its own, it isn't enough. And as a matter of law, the presence in proximity is also not enough. If there are no further questions, we ask that you reverse and vacate the convictions. Thank you.
All right, thank you. Excellent briefs by both parties in this case. We'll take it under advisement.
Whatever you want, I'm good either way.
You good for
I'm
one?
good.
All right, let's do the next case, and we'll take a quick break before the last case. Call the next case, please, Madam Clerk.
State of Tennessee versus Tomar.